Are you ready? Ready to hear a radical concept? Here it goes. This is Florida statutory law, and of course, I'm going to read it verbatim with my own commentary, and I reserve the right, as always, to fill in a little bit of opinionated language in between. Here it goes. It is the public policy of this state, Florida, that each minor child has frequent and continuing contact with both parents after the parents separate or the marriage is dissolved. That language is essentially new. After the parents separate or the marriage of the parties is dissolved. Well, of course, parents separate when they are a couple but not necessarily married, and the marriage is dissolved. So that language goes both ways. Both the parents who are married separate, or boyfriend, girlfriend, girlfriend, boyfriend, they separate. And this states continuing contact with both parents. Nothing could be more essential to the thriving and livelihood of a minor child or children. And to encourage parents to share the rights and responsibilities. Now, that is no small thing. It is one thing to have the right to time sharing with a minor child. It is an entirely other thing to endure the responsibilities. Feeding, clothing, bathing, nurturing, reading to them, making sure they go to bed at a reasonable hour, ensuring that their nutrition is up to par, anything and everything that goes along with being a reasonable and responsible parent. Unless, here's the big one, thank you, Florida legislature, thank you, government, for once, unless otherwise provided in this section or agreed to by the parties, there is a rebuttable presumption, and that means that it can be overcome, and you can have a different outcome if you prove something different is the best for your child. There is a rebuttable presumption that equal time sharing. I'm sorry, did they say equal time sharing? Yes, they did. Equal time sharing of a minor child is in the best interest of the minor child, not I don't like him, so I should have more time sharing, not I don't care for her attitude, so our kid should be with me all the time. Equal time sharing of a minor child is in the best interest of the minor child. What is the overriding standard and principle in the state of Florida when it comes to family law? The best interests of the minor child standard. To rebut or overcome this presumption, a party must prove by a preponderance of the evidence that equal time sharing is not in the best interest of the minor child. Now, a preponderance of the evidence really could be 51-49. So to rebut this standard doesn't take quite the same amount of evidence, doesn't take quite the same amount of strenuousness, perhaps, as the criminal law standard when you're trying to prove somebody's guilty beyond a reasonable doubt. This is not a beyond a reasonable doubt standard. This is a preponderance of the evidence, better than not, more so than not. Except when a time-sharing schedule is agreed to by the parties and approved by the court must evaluate all of the factors set forth and make written findings of fact when creating or modifying a time-sharing schedule. What might a future podcast hold in store for you from the Best Florida Family Law Podcast? You guessed it. We are going to go through all of those time-sharing factors. For right now, I want to make it very clear that in Florida, our no-fault divorce state, the Florida legislature made several law changes last year in 2023. It is the public policy, hear me again, hear me roar about this, that each child has frequent and continuing contact with both parents, that both parents share not only the privilege of having that child, but the responsibilities, and that equal time sharing is presumed to be in your child's best interest. That does not mean that it is. It does not mean that circumstances can warrant a different outcome. It does not mean that both parents are perfect. It does not mean that one parent is a villain. It does not mean that one parent is a rabid alcoholic who's incapable of standing upright. There are so many unique factors and unique facts in every individual case. Family law is a one-size-fits-all in some cases, which is both great, which makes everything arguable, and also unfortunate, because if the best interest of the child standard really does reign supreme, maybe equal time sharing isn't the correct result. But that is why you have the opportunity, if you so choose, to prove a different outcome is appropriate. Keep in mind, when you go to mediation or you are negotiating your case to see if you can come to a resolution, a full parenting plan, a partial parenting plan, any kind of a temporary time-sharing arrangement, consider that default standard on Florida law is equal time sharing, not whatever you feel it should be just because, or not because your relationship didn't work out and the other parent is somehow villainized temporarily, not because you think that you're the best parent that ever lived and therefore nobody can possibly compare. Family law is built upon these kinds of arguments, these struggles, these legal fights. The Florida legislature is trying to encourage a solution where every child has two parents that love and adore that child and they're there to support that child, not just sometimes, but as often as is possible. This has been another episode of the Best Florida Family Law Podcast. My name is Attorney Jonathan Jacobs of the Jacobs Family Law Firm. Nothing that we have said here today is legal advice. This is entirely informational, referential, and for your entertainment. I hope you've learned something about Florida statutory law. Please do your own research. And just in case you wish to research from today's episode, Florida Statute 6113, Support of Children, Parenting and Time Sharing, and Powers of the Court is the name of the game. See you next time.